Good morning, good afternoon, good evening, whoever you are, wherever you are. My name is Andrew Brown, and I'm a barrister at Radcliffe Chambers, specializing in insolvency law. And today we're going to be talking about void dispositions in insolvency, a bite-sized guide. So over the next 30 minutes, we're going to explore what is a void disposition, what are some of the elements, both corporate and personal insolvency in relation to void dispositions, how you can prove one, how you can defend against them, and some of the more particular and peculiar aspects of this type of claim. This is something we see a great deal of in insolvency, and it is a matter of law which simply arises no matter what. So if you do insolvency law, either as a primary practice area or even adjacent to insolvency law, you're going to come across void dispositions regularly. It is important to understand what they are. So what is the plan for today? The plan for today is we're going to discuss generally what is a disposition, what is a void disposition, and then we're going to talk through the two different sections of the Insolvency Act 1986 as it relates to void dispositions. Section 127, which relates to corporate insolvency, and Section 284, which relates to personal bankruptcy. Those are slightly different, so we have to treat them differently. We can't just treat them all at once and the same. And we'll explore the differences between those two. But before we go any further, let's talk about what is a void disposition. Well, ultimately, it concerns dispositions of property, defined very generally, we'll talk about that in a second, by an insolvent entity, either a person or a corporation, after the commencement of the winding up or bankruptcy. As a matter of law, what it does is it simply voids the transaction. Not voidable, not reviewable, but simply void. So as a matter of law, if a disposition of property falls within the relevant time, with nothing else happening, that disposition is void, and title to the asset which is said to be disposed stays with the insolvent entity. There's nothing you can do other than raise a few various defenses. The ultimate purpose is to preserve the assets of the insolvent entity, so that creditors, and especially unsecured creditors, will be able to take some sort of dividend in a pari passu fashion. The risk which is sought to be avoided is an insolvent who knows they're facing a winding up petition or a bankruptcy petition, simply disposing of all of their assets to a third party once they know they're going to be made insolvent, and nothing being left over for creditors. So that's the basic idea of what a void disposition is.